Hello members, welcome back to Agora Legis, the platform of legal minds where we discuss legal principles and make them easy to understand for everybody. Today, we're continuing with contract law 1, and we shall be looking at the concept of intention to be legally bound, or otherwise stated as intention to create legal relationship in a contract. We shall look at the meaning of that concept, the rationale, the presumptions to that intention to be legally bound, and lastly, the burden of proving that intention. And without further indulgence, I'm Counsel Ben, and let's jump right in. To start with the meaning, according to Chris in his book Unlocking the Law of Contract, 4th edition, he defines intention to be legally bound as the fact that the parties objectively intend their agreement to have legal consequences, or the parties have that willingness to be bound by whatever agreement they are entering into. In other words, this is to ask how serious are you about the agreement that you are entering into? How serious, how definitive you want that agreement to be. So here comes a question now about the test. How do we determine that people in their agreement had that intention to be legally bound? So here we rely on the objective test. In the case of Smith versus Hughes, the court held that the determination of the intention depends on the objective manifestation of the intention of the parties, but not on the undisclosed subjective intention of the parties. What does it mean? It means that it has to be objective. Someone looking at your agreement can already say that these people intend really to be legally bound. It does not matter whether you internally and subjectively you did not intend it to be legally binding. So it means that it has to be objective, the objective manifestation, but not the undisclosed subjective intention. So the court will determine it on basing on the objective tests. So now behind this principle is to set the standard that determines what is worth the undertaking of legal proceedings, what is worth court's time. Because not every agreement, the court knows that the law recognizes that some agreements are only based upon honor, are only honorable, but not legally enforceable. So this is to set, the rationale is because they wanted to set the standard of what is worth legal proceedings, and secondly, to set the standard of enforceability of legal arguments. Members, after looking at the meaning and rationale of the intention to be legally bound, we shall now look at the presumptions as to intention to create legal relationships. And these presumptions are presumptions set by law over time with legal decisions, with precedents, and they include the following. We have the presumption as to domestic and social agreement. These are agreements between spouses, between children and their parents, or parents and their children, between close relatives, and between close friends. The presumption is that these agreements are not intended to be legally binding. This has been enforced in the case of Balfour versus Balfour, where the husband had agreed to be sending maintenance to the wife, but at some point he was not able to do it, and he stopped sending. But while trying to enforce it, while the wife was trying to enforce it in the court of law, the court held that it was not enforceable since there was no intention to be legally bound, based on the fact that it was a domestic agreement, and agreements between spouses are not binding, are not intended to be binding unless otherwise expressed. But after looking at that, there is an exception to this general rule. And the exception is that these agreements can be binding if one, they are written. It is a written agreement. If it is a written agreement that so and so is bound to do so and so in this agreement, it becomes legally binding, and it is enforceable in a court of law. Secondly, if there is separation of spouses. In case of separation of spouses, it becomes a binding agreement. If people were spouses, but later on they separate and then come to enter into an agreement, that agreement is very enforceable and is intended to be legally binding. In third position, we have transaction of property or property transfer. When an agreement includes or involves transaction of a property like a land, a house, the presumption is that it is intended to be legally binding as an exception to the general rule. In fourth position, we have financial contributions. When these domestic agreements include financial contributions, the presumption is that as an exception, they are intended to be legally binding. Members, as to presumptions touching intention to be legally bound, we have the presumption that commercial agreements or commercial contracts are always intended to be legally binding. What do we mean by here? It is that every agreement that includes a commercial transactions, even if it is not clearly stated, the presumption of the law is that it is intended to be legally binding. For example, in the case of Edward Vathers Skyways, an employer promised to give to an employee an ex gratis payment. For purposes of explanation, an ex gratis payment is a payment made as a bonus for an employee. And as such, the employer did not fulfill, and the court held that this agreement was very enforceable in the court of law. Why? Because there was a presumption as to the fact that it is employer-employee relationship. So what does the court look at to determine intention to be legally bound? In presumptions, the court looks at the relationships between parties. The court looks at the certainty of the words used while making up the contract. Thirdly, the court looks at the seriousness of the agreement. Does the agreement engage a lot of money, a huge amount of money? As per reference, Section 9 of the Contract Act provides that all the agreements or all the contracts whose value exceed 25 currency points are to be put in writing, for example. So the court will look at all those factors to determine whether an agreement should be presumed intended to be legally binding or not. Exceptions as to this presumption include an owner clause. What do we call an owner clause? This is a clause in the contract that says that this particular contract is only to be honored but not to be binding to the parties. For example, someone who promises, let's say, I'm going to help you pay your tuition, and he writes it down, but he puts an owner clause that this is only to be honored but not to be bound, but not to be binding. So it won't be enforceable or is not intended to be legally binding. Secondly, when there is an express language of non-binding language, uncertainty of the words. For example, when it is said that shall, there you see that it is certain, but when there is a maybe, it is not certain. So when it is not certain, we already see that there is no intention to be legally bound. Members, after looking at the presumptions, we are now looking at the burden of proving an intention to be legally bound. So the burden of proving an intention to be legally bound, in essence, lies on the party who asserts that the contract was intended to be legally binding. As per reference in the Evidence Act, Cap 8, under Section 101, he who alleges must do what? Must prove. So the one who alleges that the contract was intended to be legally binding is the one who bears the burden to prove the fact. That is it for today, members. I hope you have grasped the principles on the intention to be legally bound in a contract, and that if there is any other question, you can just drop it down in the comment and I will be very glad to respond to them. I urge you to like, subscribe and share this to this channel. This is the only way you can uphold this vision to share legal knowledge. Thank you for watching. It is always Counsel Ben at Agora Legis.